Hi, Assalamualaikum. My name is Huzaifah Zainal and I'm from University Technology Malaysia, Skudai. Today I'm going to present a topic on the clearing the air, debunking legal misconceptions of private lease scheme. Introducing this first part of the presentation. This paper aimed to review if Malaysian legislation satisfies public concern in strata lease scheme project. The objective of the study is to identify legal issue related to the concept of private lease scheme. Secondly, is to address the legal issue based on the perspective of strata lease scheme development in Malaysia. Method is qualitative research approach, and problem statement is about the public concern on the legal rights and the justification of the private lease scheme bias, especially in Johor. Case study subject will be the public concerns in Johor project based on the new news online and articles, and Malaysian law applied to the strata lease scheme based on the Pinning project, where the data will be based on case study inputs. These are the issues that were found in the online news regarding to private lease scheme project in Johor. Moving to the second part, examining the strata lease scheme concept. Ladies and gentlemen, let us first understand the entity of strata scheme. A strata scheme is actually a stratified building which has a physical entity of a parcel, accessory parcel, the common property, and each of these units has its own strata title. These are the sample of strata title. Why do we need a strata title? Strata title is a document of ownership. From the regular strata scheme, ladies and gentlemen, let us move on to strata lease scheme. A strata lease scheme is actually formed when land lease is actually registered on all strata title in a stratified building. It involves selling a unit to a buyer by sales and purchase agreement or a lease agreement forming between the landowners and the buyers. A lease is only valid when it's registered. These are the few samples between the differences of strata scheme and a strata lease scheme. First, a registered buyer on title is registered as proprietor in a regular strata scheme, while in strata lease scheme, it is registered as lessee. The type of ownership in a strata scheme is a multiple owner, when in strata lease scheme, there's only one single proprietor because there is no transfer of ownership. The term of possession is where in strata scheme is perpetuity, while in strata lease scheme is a 99-year lease. Ladies and gentlemen, the uniqueness about strata lease scheme is that it does not have a specific law or a single law. It has to be referred to several laws, which is 9 laws in Malaysian legislation system. They are Trustee Act 1949, the National Land Code, the Strata Management Act 2013, Strata Title Act 1985, Housing Development Control and Licensing Act 1966, Town and Planning Country Act 1976, Probate and Administration Act 1959, and Small Estate Distribution Act 1955, and finally, the Federal Constitution. Now, we are on the third part and also the final part of the presentation, where we're going to address the legal misconceptions. Ladies and gentlemen, this is what we found in the study. There is several issues highlighted by the scholars based on the article read and also by authors from the online news. We have conclude and summarize the problem into themes which are lessor dominating all contracts, no rights of possession for buyers, limitation of current law, decreasing in property values, buyers were deceived, and building management issues. On the first public concern, where buyers are not protected as lease does not constitute proprietorship. Based on the case study input, a registered lease is an indivisible registration that any party cannot contest unless the registration is fraud or the registration instrument itself is invalid. The lessee has full rights to the strata unit during the lease term. This is based on Section 340, Subsection 1, National Land Code. Going into the second concern, where the limitation of buyer's rights under strata management law. Based on the case study inputs, it was found that lessee or strata unit buyers in a strata lease scheme has the same opportunity in strata tribunal as any property owner in any regular strata scheme. This is referred to Section 107 Strata Management Act 2013. Strata building issues concerned by the public where we are found based from the case study is that joint management body may be formed among strata unit buyers. However, once a strata title has been issued for each of the parcel, there will be only one owner for all strata parcels, and that single owner becomes the management proprietor. This is based on Article 2, Subsection 3, Second Schedule, Strata Management Act 2013. And finally, on the concern of decreasing in property value, where each strata parcel leased by the landlord is for a term of 99 years. This is because within the 99 years, this guarantees that each strata title unit sold is eligible for bank financing, as the bank can only permit a registrable charge on the lease. If the lease term is lower than the strata lease unit, may not be able to be favorable for bank financing. All units in strata leases have the significant reason due to the increasing land market prices. This is based on the case study experience in the state of Penang. Ladies and gentlemen, finally to conclude, the study successfully identified legal issues with private lease schemes idea and outlined the solutions. The study revealed that there is several laws that could actually address the legal concerns raised by the public, and putting in the case study inputs to actually show that the current strata lease scheme development has explained the concerns. Highlighting the relevant law helps to challenge the negative public receptions for strata lease scheme project. Thank you, ladies and gentlemen, for sharing your time with me with the presentation. And thank you to the organizer for organizing this conference.